everybody, and welcome to the latest in our series of SQE webinars. Today we're going to be looking at some of the sample questions from the suite of questions for the Functioning Legal Knowledge SQE1 assessment that we published just before Christmas 2019. I'm Julie Brannan, Director of Education and Training at the SRA, and I'm joined today by my colleague Jill Foster-Taylor from Kaplan, who is part of their academic team and who's very closely involved and responsible for the production of the questions. What we're going to do today is go through some of the questions that we have selected from the big question bank that we published. And we've selected those questions either because we think they're really nice illustrations of some of the assessment points that we have as part of our objective and purpose of assessing through the FLK, or because we have received comments or queries on those particular questions. But perhaps before we do, we can set the scene for the questions. Perhaps we can turn to the first slide, which is just a reminder of what the FLK covers. So to remind everybody, there are two papers within the Functioning Legal Knowledge assessments, each in the live assessment consisting of 180 questions. The first paper covers the topics set out on the slide, business law and practice and so on. The second paper covers the property, will, solicitors' accounts, landlord trusts, criminal law and practice. So that's the division of topics between the two separate papers. And as I'm sure those of you who follow the SQE are aware, we are still considering whether or not we should include a skills element within SQE1, and we're going about talking to people and up and down the country to gather views, and we will make a decision in the light of the findings from the SQE2 pilot. So before we look at an individual question, Jill, I was wondering whether you could explain to everybody what the process is in terms of producing the questions, writing the questions, drafting the questions before they get put into a live assessment.
Yes, of course. Thanks, Julie. Well, typically to produce questions, and obviously in the course of last year with running a pilot both for SQE1 and SQE2, we had to generate a lot of questions. So we will typically hold a question writing retreat, and those attending the retreat will be solicitors who are subject specialists in a spread of different subject areas. And we gather together. We find it much the easiest way to take everybody away from distractions, and our writers will write across 2 to 3 days and produce first draft questions. Once those first draft questions are produced, there is then a further process of editing and refining that goes on, and that will take some weeks generally. So the initial first draft questions are picked up by the academic head within Kaplan, a solicitor, and not necessarily a subject expert in the area of the question, but certainly familiar enough with the area of the question to be able to edit effectively. And there will be correspondence and editing as between the academic head and the question writer to improve the question, bearing in mind those essential qualities of validity of the question and the structure and format of the question. Do you want
to explain what those terms mean?
Well, when we have a writing retreat, we'll explain to our writers in detail how the question has to look, what the stem, the story of the question has to contain, what the lead-in, the question has to look like and how it has to be phrased, and then how the various answer options, the correct answer and the distractors, have to relate to each other, or how they have to be presented. And key things obviously are that there is only one correct answer, but also that all of the information that you need to select the correct answer is provided in the stem itself. Various other techniques that the training will introduce the writers to at the writing retreats, and all of those the writer and the academic head will bear in mind as they go forward and edit the question. Once the initial editing exercise between the academic head and the question writer has taken place, then there will be other subject experts involved in reviewing the question and making suggestions and edits and so on. That because really, although at the writing retreat, our writers write and review each other's questions, so there will be at least one other person in your subject area looking at the questions that you've drafted at one of those events. But so far, precious few people have seen these questions, and obviously the opinions of 2 people or 3 people is not really sufficient. So subject experts will then review the questions. There'll be a further process of editing, and then review again by the academic head in liaison with the writer to make sure that the question is still going in the direction it was intended to. And then the question is likely to be put before somebody who's an expert in questions, but not necessarily in legal questions, or a subject expert in that area, and they will add to the editing process in terms of format and structure as much as anything, and rationalising some of the information contained in it. And then before a question becomes released into a question bank, it will come back to the academic head and the original question writer and be finalised in that way. So it's a longish process. It's a process that needs to take time. It does take time, but it needs to, because it is a process of thought and improvement. And our experience is that if you try and write questions of the sort in a rush, you're not going to develop a satisfactory product.
So lots of pairs of eyes through that process. And I think solicitors involved at all the stages of the process. Yes, all the way through.
I mean, the only person who I've mentioned who may not be a solicitor could be the professional editor of questions, who will have a different view on the way that the question looks. Everybody else otherwise will be a solicitor.
And you made the point that there is only ever one correct answer.
Mm-hmm.
These are single best answer questions. Mm-hmm. So does that suggest there might be some answers, more than one answer that might be conceivably correct?
No, there won't be more than one answer that's correct. The STEM will introduce the candidate to the information that the candidate needs to select the best answer. So the best answer will be the best answer based on the facts that have been provided. So as you start to read the STEM, you might have all sorts of ideas about where the question is going to go, but the information required to answer the question must be contained in the STEM, and there will only be then one correct answer.
I see, that's really helpful. Let's move on then to look at the individual questions, and the first question that we have pulled out is question 69, and this is a question about covenants, and one of the comments that we received on this question was whether some of the operative facts might be missing. Can you explain the thinking behind that question, perhaps pick up that observation?
Yes, of course, yes. So question 69 in the sample pack, the STEM starts by saying that the client goes to see his solicitor because his neighbour's roof has recently fallen into disrepair. And then it goes on to say the neighbour gave a covenant for the benefit of the client's house not to let the roof fall into disrepair. There's nothing in the STEM there to suggest that the neighbour's land has changed hands. There's nothing elaborate about the description of the owner of the neighbouring land as the neighbour to suggest that the property's changed hands or otherwise devolved to anybody else. So the neighbour referred to there is a single character, and it's worth pointing out that the characters in our questions will always be described in those sort of terms. The man, the woman, the solicitor. We don't give names to our characters because of all sorts of implications that might be drawn from having a name, and so best practice in producing these questions will make sure that the characters referred to are referred to in these sort of terms.
And I guess it's simple and it describes them by their function in the scenario.
Absolutely, yes, that's right. So the lead-in, the question then asks why the client is likely to be able to sue the neighbour under this covenant, and the options all relate to the burden of the covenant. So although the idea of covenants in relation to property may raise all sorts of questions about whether or not they're positive, whether they're restrictive covenants and so on, and some of the possibilities raised there in the options, the reality is that the original covenanting party here is the person who has let the roof fall into disrepair, and therefore the correct answer here must be E. And by analysing the facts in the question, the candidate should decide that that is in fact the best answer.
So are you asking candidates to draw any inferences from these facts or to assume that things are happening?
No, they're not expected to make any inferences. They're not expected to invent any additional information. The information that they require to identify the correct answer, the best answer in this scenario on these facts, all of that information is contained in the STEM.
I see. So that's really helpful and an important message for people to take away, that when you're looking at these questions, the relevant information will be in the STEM, and based on that information you should select the best answer, and there will only be one best answer on the facts given.
Yes, that's right. Yes.
Let's move on to the next question then in the little selection, and this is question 23. And this is a question about rules of precedent. And one of the points that has been raised with us is that we suggest that the correct answer is option B, but actually that answer doesn't take into account, or the question fails to take into account the possibility recognised by the Supreme Court in Willers and Joyce No. 2 that the Privy Council may depart from English authority for the purposes of English law. What about that? Have we got the answer wrong there?
Well, of course, the case of Willers and Joyce No. 2 does make the point that there can be a departure from the rules of precedent. But perhaps most importantly, it does confirm the rule that the decisions of the Judicial Committee of the Privy Council are not binding as a matter of precedent in the law of England and Wales. The case goes on to explain the circumstances in which a different direction may be given, but that would involve the President of the Judicial Committee of the Privy Council being given information that a point where the decision of the Privy Council could be considered to be of precedent value being raised in advance of the panel being convened, and a panel being particularly convened on the basis of that information, and then a direction being received from the committee once it's sat that their decision should be regarded as representing the law of England and Wales. I think there are two things to say here, really. The first is that there's nothing in this question that suggests that that sort of a direction has been given, and therefore, as I was saying before, there's no reason to introduce the possibility that that direction may have been given. A candidate is not expected to answer the question on the basis that something might have happened which they're not told about. And the other is the point about testing of fundamental legal principles and rules, and the fundamental principle and rule being tested here is the doctrine of precedent and the status of the Judicial Committee of the Privy Council in relation to the hierarchy of the courts of England and Wales.
Yes, and I guess just to reinforce that point, a candidate shouldn't make up a fact which is not in the STEM in order to make a particular answer fit.
No, that's correct.
Yes, so just answer on the basis of the facts given, and recognise that we're assessing fundamental points of English law, fundamental principles of English law, like the rule of precedent, rather than exceptions or anomalies.
Well, of course, it is a point that we could test. That we wouldn't test it with this question, because if we said that a direction had been given, there wouldn't be anything to choose between the answers. The answer would have been given in the STEM. But if we wanted to test that point, it would be clear that we were testing that point.
Yes, I see. Good, thank you. Let's move on then to the next question that we have pulled out, and this time it's question 6. And question 6 is a question about how do you appeal against a decision of the Court of Appeal. And it looks, on the face of it, really a pretty straightforward question.
Yes, that's right. And the comment that was made was that it seemed to be a question that was testing more knowledge than anything else.
Knowledge, not application.
Knowledge rather than application,
Yes.
exactly so, yes. And I wouldn't disagree with that point. The explanation is that the functioning legal knowledge, that body of knowledge which forms part of the assessment specification, is the knowledge which the day one solicitor is expected to carry in their head and be able to apply and practice. And there are some areas within the FLK, I think the English legal system is one, and I think constitutional law is another, where some of the elements which you would expect the day one solicitor to know and be aware of are areas where to build a convincing scenario for application is very difficult, if not impossible. That means that if you want to test that knowledge, you may have to generate some questions which are much more in this style and which do look as if they're testing knowledge much more than application. I don't think that the right response would be to say, well, we'll leave those areas out of the FLK and not test them because we can't generate questions which show a high degree of application. I think the better way is to recognise that on occasion there will be a question which presents itself like this.
In this way, I see. And I guess across the body of the totality of questions, there are enough questions there which do test a candidate's ability to apply legal principle to factual scenarios so that we can be confident that candidates can indeed do that.
Oh, absolutely so, yes. The vast majority of the questions involve application.
Yes, I see. Good. So moving on from question 6, the next question we've pulled out is question 11, which is about causes of action in tort.
Yes, and this is a useful one, again in relation to the content of the functioning legal knowledge in the assessment specification. The point that was raised here is that this is a question about nuisance, which appears in the FLK, but that one of the answer options is trespass to land, which itself is not listed in the FLK. The point here really is that in relation to trespass to land, there are two broad areas where a knowledge of that area would be essential to an understanding of the topic. One is nuisance, as here in this question. The other is occupier's liability, that you need to know about who's a trespasser in order to be able to understand and apply the law in relation to the legislation for occupier's liability. The heading of trespass to land itself, therefore, in a sense, doesn't need to appear in the functioning legal knowledge because it must be an intrinsic element of a proper appreciation of the law relating to both nuisance and to occupier's liability. And I might just add that in the course of last year, when we carried out some revision work to the FLK, one of the things that had been pointed out was that in some areas of the FLK there was a huge amount of detail provided in relation to certain legal topics, and in other areas there was very little detail. There were broad heads and not much in between. And so part of what we did was to try and regularise that position in relation to the level of detail given across subject areas. And so it may well be that there are some areas which we recognise that an understanding is required in order to deal with the broader area, but we haven't listed out every single topic which we would expect a training provider to recognise needs to be taught or a candidate recognise needs to be learned in order to prepare for these exams.
Yes, so I guess what you're saying is that the essential elements of those various torts require, in this case, a knowledge of the principles of trespass,
yes.
And therefore that does not need to be spelled out as a separate head because it's intrinsic
Yes.
in other causes of action.
That's right.
Yes. Moving on again, we now arrive at question number 84, and this looks to me like an ethics question.
Yes, and just briefly, this is here to illustrate the fact that ethics is assessed pervasively, and so ethics questions may come up in the context of all sorts of different subject areas.
Yeah.
So
There's
this
no
is
big flag here, is there, in flashing lights, here's an ethics question?
No, exactly so. And you might start out on this question thinking that it was in relation to a property transaction, but a careful reading of the question will show you that it is in fact an ethics question.
Yes, and so they'll crop up in lots of different context, these sorts of questions?
Yes, that's right. There are questions in the sample pack of a question in a criminal context. There's one where a client is wanting to give false information to the court, and so on. So they test the principles of ethics, but within the context of the subject areas.
Yes, I see. Then next two questions are question 62 and then question 63 that we'll come on to in a moment. But both of these questions are about criminal law, and we've had some comments on these questions.
Yes, there was a comment saying that these two questions had been passed to two criminal lawyers, and the view was that one had two possible answers and the other was out of date. Now, without any more information, I can only guess really what those comments are. So I'll deal fairly briefly with them, but hope to get to the point that the commentator was making. Question 62, I'm going to assume that the use of the term joint enterprise is what the point is about. It is the case that some commentators have suggested that term joint enterprise shouldn't be used any longer after the case of Jogi in 2016. But although it isn't a term of art, it is still used and it does still appear in Halsbury's. So I think where option D uses the term joint enterprise, that doesn't indicate that the question is out of date. And that case itself, Jogi stated the fundamental principles about the liability of accessories or secondary parties, and those are the key principles which this question is aimed at testing. So if that was what the point was, then I don't think that's the case. For question 63, I'm wondering if perhaps this is the question which the person suggested had two possible answers. This is a question about involuntary manslaughter. The two possible ways in which involuntary manslaughter may have been committed in this scenario, until you look at the facts in detail, are unlawful act manslaughter and manslaughter by gross negligence. As regards unlawful act manslaughter, there has to have been an unlawful act which was dangerous and which caused the death of the victim. There has been an unlawful act. The man sets fire to a caravan intending to unlawfully destroy property, but not to harm anyone. So there is criminal damage here, which is dangerous and which did result in the death of the individual, the elderly man in the caravan. So the answer D there is the correct answer. For manslaughter by gross negligence, you have to show that the defendant owed a duty of care to the deceased, and then that by negligent act or omission the defendant was in breach of the duty he owed to the defendant. The negligent act has got to be the cause of death, and it's got to be shown to have amount to gross negligence. But the start point there, that you have to show that the defendant owed a duty of care to the deceased, is where we found her here, because this man doesn't owe a duty of care to the elderly man in the caravan. So although you might start out by thinking that perhaps this was manslaughter by gross negligence, I think a careful reading of the facts tells you that there's nothing to substantiate that as a possibility. So there is only one possible correct answer there.
Yes, I see. And I suppose it's quite a nice illustration of the fact that some of the distractors will identify perhaps a common misunderstanding that a candidate might have, and will just check that and allow us to distinguish between the candidates who hold those misunderstandings and a candidate who actually can apply the law correctly.
Exactly, yes. Of course, good distractors will be based on common misunderstandings or that sort of thing. Mistakes, exactly, yes.
Right, final couple of questions, I think. So the next question is question number 67. And this is a slightly different format of question, which is I think why you wanted to pull it out from the pack, Jill. This is a question which involves some numbers.
Yes, exactly. Much to the horror of many solicitors, there are some calculations in the questions that we ask. But as before, the information that's required will be there for the actual calculation to be straightforward to somebody who knows how to handle the information. And here we have an inheritance tax question. We're asked how much inheritance tax would be payable on the man's estate, and the STEM provides the information required. The key things really to notice about the STEM are, firstly, that the man left his entire estate to his nephew. That means that the main residence nil rate band won't be available on his residence because the nephew is not a lineal descendant of the man. The man was a bachelor, so there is no suggestion that he could have a nil rate band which was his spouse's, all of part of which he might be able to use, and that he didn't make any lifetime gifts, and so he hasn't used up any part of his own nil rate band. And with that information, you can then go ahead and calculate the value of his estate and the entitlement that he has to the nil rate band and reach the correct answer, which is B. The others will involve doing different calculations with different misconceptions about which of the exemptions were available to the man.
Again, so other calculations which draw out misconceptions and mistakes. They're not arbitrary figures plucked out of the air.
No, they're all based on a calculation
Which
involving a mistake.
Yes.
Mm.
And our final question, which is question 83. Why did you choose this one?
This one really because unregistered land, which is the context for this question, is something which is less and less taught, I think, in many of the training providers, but does form part of the FLK. So it's quite useful as a reminder of that fact that unregistered land is an area for testing, and a question which shows both the requirement of knowledge and application in order for the candidate to identify a good route of title. And I think partly because unregistered title has less emphasis now than once was the case, for understandable reasons, because the registration of land progresses apace, but that a sort of key idea like a good route of title is something which the candidate should both be aware of and be able to apply information provided about documents and dates to identify which is a good route of title, and in this situation the best of these documents as a good route of title. So the correct answer here is A, the conveyance, where the solicitor acting in the conveyance will have investigated title fully, will be the best candidate here for a good route of title, and the others less good for a variety of reasons.
Yes, and I suppose that just reinforces the point that, of course, unregistered title, as you say, is within the statement of legal knowledge and within the assessment specification, and that this is a fundamental point of unregistered land law.
Yes.
That completes the questions we want to go through. So thank you very much indeed, Jill, for that very helpful explanation. Just a reminder to everybody about how you can keep in touch with us if you've got any further questions that you want to raise with us, any further observations, comments, queries on the sample questions that we published. Please do let us know. The slide tells you how to get in touch and how to contact us. And can I give a shout out to our new SQE update bulletin. This is a new monthly bulletin that we will be publishing on the SRA website, which will give people up-to-date information on the work that we are doing in relation to the SQE and our ongoing programme of development. So please do take a look at the first edition, which is now there, January edition, and there will be monthly editions to come into the future. So thank you very much indeed for listening to the webinar. Final thank you again to Jill, and we hope that you found that helpful.